Welcome everyone to another session on Current Affairs by Civil 360 IAS Academy. In this session, we will be discussing about environmental clearances and the environmental impact assessment process. So recently, the Supreme Court had actually recalled one of its earlier judgment which had actually outlawed post-facto environmental clearances. So in the recent judgment, Supreme Court in a 2:1 majority said that the post-facto environmental clearance is not completely bad in law, but there are cases where post-facto environmental clearances can be given. So virtually, but it had one of the Supreme Court judge had actually dissented in this case, but the Supreme Court said that post-facto environmental clearance can be given. So we will be studying about the environmental impact assessment, the process, where does the environmental clearance actually come into play, who actually gives it, and what is the principle behind this concept. Okay, so this was the judgment. So we know that the environment impact assessment is actually as per a notification which was issued by the Ministry of Environment, Forest and Climate Change in the year 2006. Okay, so remember 2006 is the year in which the EIA notification was actually given out. Okay, environment impact assessment. In 2020, they actually gave a draft which actually it actually led to public outrage, not outrage but public dissent on which, in which they had actually reduced the time period for public hearing. So some issues, it ran into other issues and it was actually eventually withdrawn. So this is the notification that we currently follow. And this notification, like I said, was issued by the Ministry of Environment. It was under the Environmental Protection Act of 1986. Okay. So environment impact assessment, remember notification, remember the act, remember the authority which issued it. So EIA is an important topic because it is specifically mentioned in the GS3 syllabus for UPSC mains. So please study it carefully. Please understand the various steps involved. We will look into which are the authorities involved as well. So EIA process, before you study the EIA process, you need to know there are certain categories of projects according to which the EIA process is deemed necessary, which is basically mentioned in the EIA notification of 2006. So there are category A projects, category B1 and B2 projects. Category A projects are projects of larger scale which need mandatory EIA. Then you have B1 and B2. B1 actually requires EIA, but the clearance is actually given by state authorities. And B2 are categories of projects that are of less scale which do not need any mandatory EIA. So please understand that. Okay, and move on to the steps involved. Okay, please understand the different steps involved. First, the step is obviously screening, where in the party who is actually trying to build a project which is going to look into whether an actual EIA is required or not. Then it involves scoping. Next step is scoping, which is actually detailing about the project, the various aspects of the projects. Then impact analysis. Impact analysis actually involves predicting the actual impact of the proposed project. Then you have step 4, which involves mitigation and impact management. So here the party who is actually proposing the project has to come up with mitigation measures, management plans, etc. And then you have the EIA report which is being filed. The EIA report will be filed along with the environment management report as well, and they will both be sanctioned by environment impact assessment report and the environment management report. They will be given, or the authority who is going to sanction them, it's the environment expert appraisal committees. Okay, you have the environment appraisal committees. Okay, environmental appraisal committees are there. They sanction the environment impact assessment report as well as the environment management plan or report. Okay, that is under step 5. Just for clarity, there is one more thing I will show you. Okay, so this is basically the authority and which what they sanction. So here we can see screening is there, who carries state expert appraisal committee is there, they actually carry out it. Then you have scoping, then public consultation is there. So you can understand which body actually, public consultations are conducted by the pollution control boards. So that is an important point. Okay, this is actually for category B, category B1. Okay, this is actually for category B1 projects, wherein the state is the apex authority. For B1 projects, state is the apex authority. Then you have project appraisal. It is at this stage you have the EIA report, the environment management plan, etc. is filed. This project appraisal, this is the step 5 that we mentioned. So here these will be this will be sanctioned by the expert appraisal committee. Expert appraisal committee. Okay. So please remember the body which sanctioned the EIA report as well as the environment management plan. Okay. So we can see that the expert appraisal committee at the center is there for category A projects, and the state expert appraisal committee is there for B1 projects. And after that, then there will be a review wherein public will be involved, and after that the final decision, okay, this final decision or step 7, okay, that is the environmental clearance that we are talking about. Okay, that final approval. So essentially in 2017 what the government did was that they issued a notification which actually allowed project proposers or to actually carry out the project without actually getting the environmental clearance. So they can carry out the project, and after the project has run, after a time period, they can actually conduct or they can actually seek the environmental clearance. That is what we call as the post-facto environmental clearance. So this is the process. Okay. So one more thing. Please understand who actually grants the environmental clearance. It's actually given by, for category A projects, it's given by the Ministry of Environment, Forest and Climate Change, and for category B1 projects, it's given by the state EIA authority, that is Environmental Impact Assessment Authority. Okay, so please remember, EIA report is sanctioned by expert appraisal committee at the center and state for A projects and B projects respectively. For environmental clearance, the final approval, it's actually granted by the Ministry of Environment, Forest and Climate Change for category A projects, and for B projects, state environmental impact assessment authorities. Okay, so please remember which authority is sanctioning the environmental clearance. Okay, then the final step involves monitoring, which is actually the post environmental clearance, which is monitored by the SPCB, State Pollution Control Boards, or the Central Pollution Control Boards, depending upon the project, category A or category B. So remember the different authorities involved. Okay, and also remember the different projects. Just have a general idea, because they might simply ask, right, which projects need EIA, okay, which project is category A, which project is category B1 or B2, they can ask. So please understand, category A is large scale nationwide impactful projects like thermal power plants that have an energy capacity of greater than 500 megawatts, mining projects that cover greater than 50 hectares, then river valley projects generating greater than 50 megawatts. So please read and understand, have a general idea, or at least study one of the categories where you do not need mandatory EIA, which is category B2, because then you can eliminate the other options. Okay, so please just know that mining is an important project, and less than 50 hectares, it's actually a category B1. Greater than 50 hectares, you need permits from the center. Highway expansion. Highway expansion is a state. Okay, it comes under the state authority B1 projects. So please, have a general idea of which project can be in where. Large scale projects, category A. State level kind of like scale projects are in B1. Smaller projects, further smaller projects are in B2. Okay, solar thermal plants, small area development projects, Industrial estates without housing and without polluting industries, etc. MSME mining, that is less than 5 hectares. Okay, less than 5 hectares. Okay, so hope this is clear. Please have a general idea regarding this as well. Okay, so this is the environmental clearance, which is the final output of the EIA process. Okay, and it's actually granted by the Ministry of Environment, Forest and Climate Change and the State Environment Impact Assessment Authority at the state. Please understand that it's different from the EIA report expert appraisal committees. Okay, so please understand this. Okay, now the concept of post-facto environmental clearance. I already explained it. In 2017, Ministry of Environment gave a notification which allowed the party to go ahead without completing the EIA process. Okay, but if you think logically, it actually violates a very fundamental principle. We discussed that principle in another video, is the precautionary principle, right? That is, if there is any chance that a particular project can actually cause some damage to the environment, then it is better to avoid it. That is the precautionary principle, unless it is overridden by a scientific study, and that scientific study is actually EIA, right? So environmental clearance does not actually take that EIA to the logical conclusion. So the post-facto environmental clearance actually short circuits the EIA process, so that it violates the precautionary principle, right? So they may ask, it violates the polluter pays principle. Okay, so please understand, it actually violates the precautionary principle. Okay. So they can also ask they can give a list of case laws and ask, these case laws are related to which of the following, right? So remember, in Common Cause versus Union of India, in Alembic Pharmaceuticals versus Rohit Prajapati, Vanashakti judgment is an important judgment, because in Common Cause and Alembic Pharmaceuticals, the court held the stance that post-facto environmental clearance, they are not so good, but we are not strictly striking them down. But in Vanashakti judgment, Supreme Court said, post-facto environmental clearance are completely bad in law, they cannot be allowed. Okay, but that was actually given for review under Article 137. Okay, so please understand that they were actually submitted for review by the Confederation of Real Estate Developers of India. They said that many projects were used that 2017 notification of Ministry of Environment to continue their projects without post-facto environmental clearances, and they all will be left high and dry if the Supreme Court actually carries out the Vanashakti judgment, which struck down the 2017 notification itself. So this review, then the Supreme Court in a 2:1 majority, one judge actually dissented, Ujjal Bhuyan judge actually dissented, but other CJ and one more judge was there. They said that the post-facto environmental clearance cannot be held completely bad in law. Okay, so they actually gave a kind of a principle. They said that if the adverse consequences of refusing to grant an ex post facto environmental clearance outweigh the consequences of the regularization of operation of the establishment by the grant, then so basically they conduct a cost benefit analysis. So if they say that there is no post facto environmental clearance, it will cause a certain amount of harm, right? And if we allow the post facto environmental clearance, it will also cause certain amount of harm. So which harm is going to outweigh the other? If such a case is there, then they can allow the post facto environmental clearance. So if I am a project proponent and I actually use the 27 notification, I actually built a large housing colony or a mining project that's greater than 50 hectares, large one, and if I'm going to shut it down, maybe it will involve a lot of demolition, construction, or sort of lot of destruction is going to be caused. It is going to cause financial loss. It is again going to cause environmental degradation. This was the logic of the CJ and the other judge. So they said that in such a cost benefit analysis, it is better if we allow the post-facto environmental clearance. But the other judge said no, it is actually violating the precautionary principle. But since 2:1 majority was there, so as of now, post-facto environmental clearance is valid. Okay, the 2017 notification is valid, and it is now possible in India to carry out a certain projects without getting the environmental clearance. So please understand the gravity of the issue. Okay, remember Vanashakti's judgment. Remember the current stance as well. Okay, so this is a sample question. Which of the following processes typically require a prior environmental clearance under the EIA process? Okay, so normally we can say that educational institutions, if we see that educational institutions are not actually there, right? So environmental educational institutions, we can actually cut them. Right. So, so here, if we can eliminate educational institutions, we will reach either A or B, right? So A or B is there. So we can, if we have a certain idea as to the, what can I say, the projects that we saw earlier, right? We saw the river valley projects, mining, we saw highway expansion was there. So these kind of projects, they need an environmental clearance, okay, typically, right? So basically typically means, please understand, there is post-facto environmental clearance. They say that typically it means in normal case. So do not go to the post-facto environmental clearance, okay? So but we can eliminate educational institutions and we will reach A or B, right? And if you have some idea regarding that, which projects were there, so we will reach option B. River valley, mining and highways. All these typically require an environmental clearance. Okay, so that's all on this session. So please read up on the EIA process. It's an important part of your GS3 syllabus. Please remember the type of projects for which EIA is actually required. Remember the recent judgment. Remember the process involved in the EIA chain. Remember which authority actually sanctions which. Okay, so please study it carefully because it's an important judgment. It has a lot of impact on the environmental law on the country. So that's all in this session. See you in another session on current affairs. Thank you.